By RE/MAX Diamond Realty.
All right, we have got a big question for you for House to Home this week. What if you have property coming your way by way of a will? Maybe somebody bequeathed you property, maybe an entire house that's already built. I have Liz and Gina here from RE/MAX Diamond Realty, and we are going to find out what will happen if someone wills you, deeds you property at that point? If someone passes, along, obviously if somebody sets up a will, ladies, they've taken proactive steps to, make sure that whatever property they have is passed to people that they want it passed to. But how difficult a process is it at that point?
Well, when they come in, they say, well, the property was given to me. Here I have the will. The will just states the intent of the person that passed away, what he wants done with that property. They come in and it's not cash. You can't do anything with it. We can't do anything with it. It just shows intent, who the property is going to go to. So that party would have to do a number of things in order to transfer the title in their name. It also complicates it if there's more people on that will. So I guess the question we would ask is, yes, it's a will. Do you have a probate? Has a probate been established? Because the probate, it would have to go to court, and then the judge at that point, once he approves that this will states, okay, Jason, you get the house. Okay, then the judges would have to look at it and say, okay, the will states you're going to do this. If there's more than you involved, let's say in a estate, provided, of course, the other members don't protest or challenge it, and then of course the court can do whatever they do. But of course you'd have to go to your attorney. They would give you the proper advice in terms of doing it. We have to stress we're not attorneys.
Right. So that would be the first step. Yes, you have to go to a lawyer.
Yes, you'd have to make sure that's done. Otherwise, if you come to us with this document, we really can't do anything with it.
How enforceable is that document, Gina? Because this is something that people would keep in a safety deposit box, maybe a safe in their house and everything like that. And they're like, hey, I've got this. At the time it was signed off on by a lawyer or notarized or whatever the official, stamp of approval has to be.
Yeah,
and
exactly.
it's a legal binding document. But if I just bring this to you and say, I know I've got property coming from, relative rich Uncle Moneybags and everything like that.
Or your parents. Yeah. Or your parents. And I do, first of all, I want to advise everybody, if you're going to prepare a will for your children, okay, that shows intent, but make sure it's witnessed by somebody that's reliable. Make sure it's witnessed by somebody else, not the person you're trying to give the property to. Because as Liz mentioned, for instance, we have 3 kids. If we decide we're going to will the property to only one of them, the other kids could contest it somehow, if it wasn't witnessed properly. And the real question is, so what do I have if I have a will? You have the person's intentions. You know what their intentions were. But now that will has to go to court, and the judge has to give you the title. It's not automatic. So if you come to a real estate agent and you say, here's the will, I want to sell the property, we can't do anything for you right now. Okay. We could guide you, but we cannot sell the property for you.
There is my next logical question, because if the title was, at least in theory, the title is passed to me, you guys know the way I think. I'm very pessimistic, glass is half empty and everything like that. Does that automatically mean I assume all of the debt and everything that comes along with that property?
If the property was deeded to you, you assume everything, title and everything associated.
So when I have a piece of paper, the will, that says the intent would be that I would be passed, does that automatically mean that I'm deeded? Because that's why I'm kind of confused, like the deed and the will.
No. It just says
two separate processes. Okay.
Two separate processes.
Okay.
The will just says, okay, my intent is I want Jason to have this house. So there are other steps you have to take to get the home. And as Gina puts it, if your siblings contested, then you'd have to go through that process in court where it goes through the process. And if they show up in court and say, I don't agree that this home goes to Jason because I wasn't there, it wasn't witnessed properly, and they go through all that series, then the judge is going to have to make a determination at that point. So the onus would be, like Gina puts it, make sure they document it, make sure they state. Now, there's many other ways to deed property to you, and we can discuss that in another show. But
okay, because I'm just wondering, it's like, oh wow, like I've got some, some great uncle who, you know, somehow found me and said, you know, I would like you to carry on, you know, the family tradition or, you know, your legacy, so you can do that. And yet all of a sudden I've got a house, like say in Switzerland and everything like that, that's worth like $3 million, and all of a sudden I've got all of that debt upon me. That's not the case though, right? Do I have to accept?
Well,
the
if they
deed,
if they will it to you, now they're two different things: will and deed. The will is not a deed.
Okay.
The will is just the intent to say, I am giving it to Jason. Now you'd have to take that will and go to court to make sure it's official. Now, if the court states, yes, this property goes to Jason, then they'll put it in the form of a court order. Once that court order is in place, of course, then you can take that to land management and go through the process.
Okay, again, pessimistically, what should happen if I become incapacitated somehow, you know, like I just take a really, really long nap and like property is willed to me, and for whatever reason, I'm not, you know, I become an astronaut and I'm on Mars for the next like 5 years and everything like that. The property is never allowed to be even the intent to be. Where does it go from there?
Well, first, if you've got a will and the will is giving you real estate properties or anything, frankly, it could be anything. It could be a car, could be jewelry. But in our business, we usually have people come in because they've got a will to real estate, right? You know, I'm inheriting this house. I'm inheriting all of this land. Let's say you're incapacitated and you're unable to have that probate. Because first you have to go to court and you have to get an attorney to start the probate process, which is getting a judge to look at the will, letting all the possible heirs know, hey, Jason's getting this property. Does anyone have an issue with this? And that's a court process, which is going to cost money. So Jason, you're pessimistic. I want to tell you in advance, you're going to have to pay for that. There is no benefit that does not have responsibilities attached to it, okay? It is just the way of life.
No such thing as a free lunch.
Yeah,
No
free
such
lunches.
thing as a free lunch. So yes, you're going to inherit the house, but before you could get ownership, you got to go to the court, pay the attorney to open the probate, pay the court to start the process, and you know, if nobody protests, then you're going to get the property. If you're not around to do that, let's hope you have heirs, a wife, a mother, somebody that can start the process for you.
Well, tell you what, there's no such thing as a free lunch. I'm glad you brought that up. We got to go to commercial right now, but there are such thing as free donuts, and I'm going to buy you guys a couple donuts, and let's go talk about this more. We'll be back next week with the continuation of this very interesting discussion, so we'll see you on the flip side of this break.
Closed